Good morning to all of you. Welcome to Legal Minds by Sai Babu Sankara. In the last video, we discussed about Arnesh Kumar case, Arnesh Kumar versus State of Bihar 2014, wherein specific guidelines were given by the Honorable Supreme Court of India regarding arrest or regarding 41A notice for the offences punishable below 7 years. In this judgment, it was also noted that if the police sends any person for remand, then the magistrate has to satisfy whether Arnesh Kumar guidelines were followed or not. That means whether that man was called under 41A crpc or not. If the magistrate does not do so and mechanically remand, definitely he is also liable for departmental inquiry as stated in the judgment itself. So this was envisaged by the Kerala High Court. In the case of Gopika Jayan and another versus Faisal MA 2022 judgment. Right. Justice Alexander Thomas and Shob Annamma Yeeper, both of these two judges bench, they have called for the explanation from the judicial magistrate for remanding the accused without satisfying if the arrest was made in compliance of Arnesh Kumar versus State of Bihar case or not. Normally, already I told you, if at all any person is arrested, please remember, Arnesh Kumar judgment, 2 or 3 points let us discuss because always it has been coming into discussion. Number 1, no person should be arrested arbitrarily because it is a violation of his fundamental right under Article 21 of the Constitution of India. There should be no arbitrary arrest. So when once you decide that the case is made out against him, that he is connected with the case, then you can arrest him. So the arrest should not be arbitrary or without any thinking. Second, if at all if the police officer wants to arrest him, first of all he has to give a notice under 41A crpc in cases below 7 years. Then he has to ask or he has to furnish the reasons for the arrest also. Then if at all the person is produced before the court under 167 of the CRPC, you may be knowing, remand. So the magistrate has to satisfy whether the guidelines of Arnesh Kumar they have been satisfied or not. Then suppose if the police officer does not want to arrest him, they have to send the intimation to the court within 2 weeks as to why they did not arrest him, because if they think that it is sufficient that he will attend the court, after all you know already I have been telling you 101 times that the purpose of arrest is to see that the person attends the court on the dates of adjournment. Of course, in view of the police, the purpose of arrest is to maintain law and order, to curb the crime, or it is a part of the prevention of crime, whatever it is. So if the police officer is satisfied that this man will come on the next day, definitely it is suffice if he releases him with a 41A notice. Right. Now coming to the facts of the case. It is a case in crime number 44/22 of Kerala State. For me regarding Kerala State. So the peculiar circumstances are that actually this Gopika Jayan, she has been alleging harassment from her mother's partner, I can say, or Telugulo మనం ఉంచుకున్నాడు అంటాం కదా, paramour maybe. But from I can say that because of legal language, she is facing harassment, sexual harassment from her mother's partner, already father died. She informed that same to mother, but she kept silent because she has to have the intimacy with the other fellow. So she did not take any action. Ultimately, a stage has come that mother threatened her to sleep with him. If not, don't come to the house. Already this woman is a widow. She is having a child also. She is staying with her mother. Mother is already having that so-called dirty habit to the other fellow. So On one day, the mother filed a case against this woman, Gopika Jayan, that she threatened her, she went away from the house, leaving the child, 506, 505, like that. A case has been registered. Then, so actually, leaving the child, it comes under section 75 of the Juvenile Justice Act also. And a case was registered, and ultimately this woman was produced before the court along with the remand report. The magistrate automatically remanded her. Now, when the matter has come to the High Court, they have gone threadbare into the issue, and they decided that 506, 504, whatever it is, they are all offences below 7 years. Even leaving the child, it comes under section 75 of the Juvenile Justice Act. Yes, it is also not punishable. It comes under the purview of 41A crpc. But the police never mentioned that they are not satisfied with the explanation of the woman. They are thinking that this woman may escape. Like that, they have not written. They have not stated even that they have called the woman under 41A crpc. Simply, they have submitted the remand report, and the magistrate asked the remand of this woman to jail at Kokonada or some place, Kerala state. And the girl was sent to a borstal school. Her child was sent to a borstal school. Now, the High Court, Honorable High Court of Kerala took it very seriously. They filed a case of contempt against the police. And as per the judgment, they asked for the explanation of the magistrate for simply mechanically forwarding the remand. That's all. He has simply given the remand. He has not satisfied himself whether Arnesh Kumar judgment was followed or not. So here, two aspects. Number one, police should follow AK judgment. There is no other go. If the offence is below 7 years, yes, they have to follow the judgment, of course. If they are not satisfied that the person is, if they are satisfied that the person is likely to go away from India, yes, they can arrest him. There are so many reasons for arresting, but the arrest should be informed to the court. Normally, the thumb rule is they have to be satisfied with 41A, and they can release them on bail itself if the offence is below 7 years. So here Arnesh Kumar judgment has come again, once again the case, and courts are very serious about the same. So please read the judgment. This judgment, Gopika Jayan and another versus Faisal MA, as well as Arnesh Kumar judgment also, so that you will be enriched with the legal knowledge. Thank you very much.